Okay, our next video vignette with regard to the Kentucky Realtors statewide contract is going to be on the property/offer section. If you've got that in front of you, you see that begins on line 21 and ends on line 37. Again, we're using those numeric numbers that run along the left side of the page. Paragraph 1 constitutes the offer that starts on line 22, and let's talk about that. Now, it says that the buyer agrees to buy and the seller agrees to sell the real property located at. Typically, the buyer's agent is filling in this information and is probably getting it from the MLS. It goes on in line 24 to indicate that this is the same property that's being recorded in deed book and page and block number and lot number and sublot, and in the appropriate county of Kentucky. Believe it or not, this is where a lot of mistakes can happen. So let's talk about it for a second. Anytime you are taking down a property description, you are transferring it to another document, and then that document is being used to create another document, there is quite a likelihood of a number being transposed or something being lost. I think we can all go back to school and remember in elementary school where you whispered in one person's ear and it kind of went to a few people. By the time that story got to the end, it had substantially changed. So our goal is not to expand on that problem. Our goal is to reduce the chance of that likelihood occurring. So let's talk about how this process would go. Essentially, you would initially put the common address, if you were putting together this contract, you would put the common address that was reflected on the MLS, assuming that's where you had located the property. Now, that may also include the deed book and page and block number and lot number and sublot. And hopefully it will also include the county. But here's a suggestion. I'm a firm believer in making sure that if there is a mistake, we somehow catch it. Having done title insurance defense for a lot of years, I'm aware that these mistakes can happen. They can be completely innocent, but they can result in a lot of confusion or misunderstanding at the end. So since you're submitting the offer as the buyer's agent, I think you should use the property address that's referenced in the MLS, but I would also include this language on line 23. And as advertised in MLS number, and then insert the ad number. Why am I saying this? Because if you forgot something, and it's entirely possible that in the busy schedules and times that we function in, that's possible, by referencing the ad, you're saying, okay, here's what I think it is, but if I'm mistaken, we're going to follow also what the ad says. We're going to add to my description whatever is contained within the ad. So if you forgot to reference a sublot, or you forgot to reference some little strip of land that wasn't in the main body of the MLS, but it is on the MLS advertisement, you've now incorporated by reference that description into your offer. And that may be a saving grace down the road. So you're going to want to include that. You want to double check the deed book and page as listed in the MLS and make sure that's accurate. And here's a thing, you really want to make sure you get that county correct, especially if by chance that land sits in two counties or close to a county border. It's quite possible one portion of it may stretch over into the adjoining county. You want to make sure you include that, one, just for your knowledge and to make sure that it's clear that all the parties that both portions of this property, even though they're in two separate counties, are being transferred. But also it assists the closing attorney later on to make sure that the recordation of the deed and the subsequent mortgages takes place in all of the counties that are necessary. Now let's talk about what tends to be a very big issue in real estate transactions, especially on the residential side, and that is the transfer of fixtures and personal property. First, let's talk about what is a fixture. I saw a recent article in the Courier Journal where it interviewed several different attorneys and asked them if they could define a fixture. What should have been a simple Black's Law dictionary type answer was expanded into a 3-column discussion of what constitutes a fixture. So when people ask me that, I always say, much of it is in the eye of the beholder. But if you know going in that there is some ambiguity and some misunderstanding of what that is, then your description of items should be expansive and inclusive, as opposed to just reliant upon what you believe a fixture is under the law, because a lot has changed. Now, a fixture typically meant something that was affixed to the property. Now, what does affixed mean? A picture hanging on the wall normally is not affixed to the property. Now, if that picture hanging on the wall, let's say, though, is drilled very far into the wall, is sealed behind the drywall by bolts or what have you, then you have a question. Is it, in fact, a fixture? Also, generally speaking, any kind of appliance or what have you that is affixed to a utility would be considered a fixture. So, a refrigerator that is connected to the water line is affixed to a utility or service or what have you. That would generally be considered a fixture. However, a refrigerator that you simply slide in and slide out and plug into the wall, typically speaking, would not be considered a fixture. And there's all sorts of different interpretations that can take place. A shed in the back that is drilled into and or sealed with concrete to the ground would arguably be a fixture, but one merely sitting on the ground, held down by sandbags, might not. And again, you don't want to get in the decision-making process of what is and what is not. So if there's any doubts and you want it to stay, you need to make sure you reference it. By the same token, if there's any doubts and you want it to go, you need to make sure that you reference that as well. So let's talk about how you would do that on the statewide contract. On line 25, it says that you are purchasing this property together with all improvements and fixtures, if applicable, which are acknowledged by all parties not to be personal property, including but not limited to. And then it gives a list of a whole bunch of different items. So the assumption is going to be that these items are going to stay with the property and by agreement through contract are in fact fixtures, even if you believe they are not. So if you are representing the seller and the seller says, well, those blinds are not really affixed to that window, there's just a rod holding them there. Well, that may be the case, but because this contract says that blinds and shades should be considered fixtures, then regardless of what they truly are, it would appear that they are in fact going to be considered fixtures and are going to have to stay with the property. So you can see where two different parties can have a different view, and if there is a dispute along the view, normally the negotiated term will take precedence, meaning the contract will take precedence over what it is actually under the law. That kind of makes sense. So let's talk about this. If you have your seller thinks that something should stay, you should go over with them and explain, that's fine. Then we need to clearly write down that this is not staying. And if we see that sent to us in our counteroffer, we need to say, blinds and shades will not stay. Even if it's obvious they aren't a fixture, because the document reclassifies them as a fixture whether they are or whether they are not. So you want to walk them through each of those bulleted points so they clearly understand that these items are staying unless they offer a counter back. On line 32, it also says appliances and additional items to remain. Well, we've talked about the refrigerator. Well, if it's connected, it's considered a fixture. If it's not connected to the water line, maybe it's not. Stoves and ranges, maybe if they're hardwired into the property, they might be considered, or the gas line, they might be considered fixtures normally. We don't know. So we want to make sure that we clarify it. And what we're doing here is, because there's a range of possibilities, on line 32, they are wanting the buyer to signal whether or not they want to keep those. So the refrigerator, even if it's a fixed, if you want it to stay, you need to go ahead and proactively check that. The same with the stoves and the ranges, the dishwashers and the microwaves. Anything of those that you want to stay, even if you believe they are a fixture, you should go ahead and check that. And this is something that you should take the time to carefully walk through your buyer with, because this is one of the most controversial issues that we get, and one of the most common calls we get is related to fixtures. Now, if you go to line 35, it says, seller shall remove the following fixtures prior to delivery of possession. So let's talk about that. You have a wonderful refrigerator in the kitchen and you think it's fantastic and you want to stay. You're going to check line 32. You're going to mark refrigerator, okay? But what if there is also an old, like, leftover from college refrigerator in the basement? And you don't want that, because you don't want to have to, one, you don't even know if it works. Two, you don't even want it. And three, you don't want to have to get rid of it later by dragging it out of the basement. Then you need to address which refrigerator you are wanting to keep in line 32 and which refrigerator you are wanting removed on line 35, where it says seller shall remove the following fixtures prior to delivery of possession. Now you may say, well, but Jason, the first refrigerator is clearly connected to the water line, and the second refrigerator is merely a slip into the area and is just a plug. I shouldn't have to define it. Well, there's an argument that maybe you shouldn't have to define it, but why take the chance in arbitration or in mediation or in court when you can clear it up as a professional in the beginning? And that's really what you should focus on doing, is clearing up confusion at the beginning, as opposed to relying on the judicial system to clear it up later on. So if there is a question, if you want to keep a refrigerator, make sure you put it in that additional area in line 32, 33, and 34. If there's something you want to remove, make sure you put it in line 35 or 36. If there's not enough room, add it to the back of the contract and say what you want to keep or what you want to have the seller remove. And then finally, we get to line 37. Now, line 37 talks about fuel and propane tanks, whether or not they shall remain, whether or not they shall be removed, whether or not they are owned, or whether or not they are leased. So, for example, a propane tank may in fact be leased for a nominal fee every year from the propane company, and it may be underground. Now, a lot of the propane contracts and a lot of the state law talks about how the only people that can service that propane contract, for example, are that particular propane company, because they own it. And you need to address that now, because even though it's in the ground, you arguably don't own it, and there is a lease agreement that you may not have remembered as a owner that you sign every year, or that you signed at the inception. So attempting to convey it to a third party, a buyer, when in fact you don't own it, could create a whole lot of problems. So you want to make sure that you walk through that anytime you have a gas or propane storage tank on the property or underneath the ground. You want to really make sure that you walk through that process with your buyer. The idea behind this section was we wanted to make sure that these items were discussed, as opposed to just relying on the default language of what is or is not a fixture. Because there was so much controversy and so much had changed with the way homes were transferred and sold, we really want you to take the time. We've itemized things here for you to talk about, and each item, each bullet point should be discussed with your buyer so as to avoid any confusion. And on the listing side, when you get the offer, you should sit with your seller and talk about each and everything, because as we know, some of these things could be very expensive. Satellite dishes, television mounts, you name it. There could be thousands upon thousands of dollars being overlooked if we don't walk through with our clients on each and every point. Our next vignette will be about price and terms. Our video vignette will be about price and terms. It's going to be a little longer. There's a lot to unpack in that section, and we look forward to communicating all we can to you about this and help you in utilizing the Kentucky REALTORS statewide contract.